Good morning, everybody. Come find your seats. We're going to begin. I just got the signal that we are also streaming live, so I want to welcome the few hundred people that are watching us wherever it is you are in the comfort of your home, and we're glad that you are able to be with us. And of course, want to welcome all of you here this morning. I'm Rabbi Chemerinsky, for those of you who forgot. It's been a couple of months. Back from sabbatical and very excited to be here and really to thank you. To be here this morning for two reasons. Obviously, to hear the wisdom of our guest who is going to be introduced in a few minutes, but also to honor the memory of our dear and beloved Lisa Tudson. Yehi zichrona livracha, may her memory be a blessing. And so we gather for those two reasons. And as I said, for all of you who are here, who just enjoyed that wonderful breakfast, thank you, Men's Club and all of the volunteers. And particularly to Carrie Fox, who is the head of our programming committee and a member of our board of directors, who put everything together and arranged everything. Thank you so much, Carrie, wherever you are. So come on in, everybody. Find your seats, spread out, be as comfortable as you want. During my sabbatical, one of the more memorable and enjoyable times that I spent was in learning. And one of the many sources of learning was the Hartman Institute, run by Rabbi Daniel Hartman. In a podcast on defining liberal Zionism, which would make a wonderful talk for another time, Rabbi Hartman, in defining liberal Zionism, commented on a text that we are all very familiar with. Genesis 1:26, when God created human beings. And God said, "Let us make man in our image after our likeness. They shall rule the fish of the sky, the birds of the sea, the cattle, the whole earth, and all the creeping things that creep on earth." What is this verse about, he asked. What does it mean to be created in God's image? A fair question, an important question. He suggested that this verse is about power. We have been created with the God-given ability to rule the world, to have dominion over all creatures, which we quickly learn can become easily abused. Soon after this power, right, we see that the world is shortly destroyed. So two things occur. First, God redefines power. Whoever sheds the blood of human by human shall his blood be shed, for in God's image did God make humans. Being created in God's image reminds us of the constraints of our power, recognizing that all humans are equal and of infinite value, which is demonstrated in the second occurrence of God's power constraints, when God says before destroying the cities of Sodom and Gomorrah, "I have singled Abraham out that he may instruct his children and his posterity to keep the way of the Lord by doing what is just and right." To be created in God's image is to use our power for justice, for righteousness, not necessarily for war, as conflicts around the world continue to remind us, but rather to be responsible for our world. As Abraham challenged God in that moment, will the judge of the whole earth not deal justly? Power to be used in partnership with God to ensure that justice and equity are the pillars of human civilization. We gather today to hear from Dean Erwin Chemerinsky, one of our country's most renowned scholars on constitutional law and civil procedures, who has made a career in trying to define the proper use of law for the sake of justice and righteousness. In a moment, Michael Tudson will formally welcome and introduce him to us. His presence here this morning is a reflection of the life well lived by Lisa Tudson, zichrona livracha. Lisa dedicated her professional life to trying to right through law the wrongs and injustices of our world. If justice is about fairness, if justice is about taking into account the inalienable and inborn rights of every human being, of ensuring that all people are treated equitably and with kindness, then Lisa embodied and personified integrity and moral rectitude. You wouldn't always know in her demeanor, quiet, reserved, modest, but ask those from her professional community who held her in the highest regard, who recognized her integrity of character as she demanded fairness before the law for those needy and always admired the integrity of others. Her friends and family could share countless moments where Lisa stood up for those less fortunate, for those who needed her strength and determination in correcting injustice. Within our community, we marveled at Lisa's generosity of spirit, her commitment to Avodat HaKodesh, holy service to our Kehillah Kedoshah, and to God through her remarkable volunteerism and her quiet way of making a significant difference in so many of our successes. Lisa was beloved by her family and friends as she walked always with courage, with kindness, and with beauty. To her parents, Marion and Peter, thank you so much for establishing for our synagogue this lecture series most fitting to Lisa's personhood. To Sarah and Hannah, may the memory of your mother's kindness and strength continue to fill your hearts and souls with her courage of conviction. To her brother Mark, may your years together continually bring you inspiration. And to her Besheret Michael, may the love you had for one another be your continuing source of strength and nourishment in your many years ahead. To all of us, may we have the courage and dignity to learn from Lisa, to live the words of the prophet Micah, who asked, Ma tov uma Adonai doresh mimcha. What is it that the Lord requires of us? Ki'im oset mishpat ve'ahaft chesed v'hatznei lechet im Elohecha. But only to do justice, to love mercy, and to walk humbly with God. May her soul forever be a blessing to all of us. Amen. Michael, please come and introduce our wonderful speaker this morning.
Good morning, everyone. The Hebrew Bible possesses a passion for justice. Justice for the poor, the weak, and the despised. Our patriarchs and matriarchs consider justice and compassion to be of paramount virtue. It has been written that one cannot claim to love God and not be passionate about justice. That is the primary Jewish contribution to the human spirit, to the operation of a just, compassionate, and civilized society. We're here this morning in memory of Lisa Schwartz-Tudzey, which has been made possible by the generosity of Lisa's parents, Marion and Peter Schwartz, and the enormous generosity of Erwin Chemerinsky, who, as you will hear, is a brilliant legal scholar, a man guided by justice, and a mensch's mensch. Erwin Chemerinsky became the 13th dean of the Berkeley Law School on July 1st, 2017, when he joined the faculty as the Jesse H. Topper Distinguished Professor of Law. Prior to assuming this position from 2008 to 2017, he was the founding dean and Distinguished Professor of Law and Raymond Pike Professor of First Amendment Law at the University of California, Irvine School of Law. Before that, he was the Alston and Byrd Professor of Law and Political Science at Duke University from 2004 to 2008. From 1983 to 2004, he was a professor at the University of Southern California Law School, including the Sidney M. Ermis Professor of Public Interest Law, Legal Ethics, and Political Science. Lisa was one of Dean Chemerinsky's students when she attended USC Law School during 1984 to 1987. From 1980 to 1983, Dean Chemerinsky was assistant professor at DePaul College of Law. Dean Chemerinsky is the author of 14 books, including, soon to be 15, including leading case books, treatises about constitutional law, criminal procedure, and federal jurisdiction. His most recent books are Presumed Guilty, How the Supreme Court Empowered the Police and Subverted Civil Rights, published in 2021, and The Religion Clauses, The Case for Separating Church and State, published in 2020. He's also the author of more than 200 law review articles. He's a contributing writer to the opinion section of Los Angeles Times, writes regular columns for the Sacramento Bee, the ABA Journal, and the Daily Journal, and frequent op-eds in newspapers across the country. He also frequently argues appellate cases, including before the United States Supreme Court. In 2016, he was named a Fellow of the American Academy of Arts and Sciences. In 2017, National Jurist Magazine again named Dean Chemerinsky as the most influential person in legal education in the United States. In 2021, he was named president-elect of the Association of American Law Schools, and he is currently treating for insomnia. On a personal note, Dean Chemerinsky is a person that I admire greatly as a brilliant legal scholar, an incredible teacher of law, exemplary human being, and a true match. I know that Lisa felt very similar about Dean Chemerinsky. How appropriate it is to have Dean Chemerinsky as our inaugural speaker, who is here in honor of the memory of Lisa, the person who I admired more than anyone or anything. I give you Dean Chemerinsky.
This is sweet. Thank you. Michael, thank you so much for that incredibly kind introduction. Rabbi, thank you for your kind words. It's a tremendous honor for me to be able to speak here today for this inaugural lecture in honor of my former student, Lisa Schwartz-Tudson. I can't tell you that I remember all of the students that I've had in the last 42 years, but I vividly remember Lisa. In fact, I even remember meeting her for the first time in an elevator at USC Law School when she was beginning law school. And she gave me such a warm, such a all-embracing, just smile and greeting. And that's how I remember Lisa. She had been a student of mine in constitutional law, and I worked very closely with her in the McCourt program. And as I think of her, I remember her keen intelligence. I remember her passion for justice. And I remember, including from the first time I met her, her tremendous warmth and kindness. I extend my deepest condolences to her family. And as the rabbi said, may her life always be a blessing to you. This morning, what I want to talk to you about is a sobering topic. I believe that American democracy is in great danger. No form of government lasts forever. We've seen across the world that democracies are there until they're not. We came closer in December of 2020, in January of 2021, to losing American democracy than ever before in American history. Never before in American history had a defeated incumbent president try to stay so hard in office. There have been defeated incumbents before. John Adams in 1800 lost his bid for re-election. You continue all the way to 1992 when George H.W. Bush was an incumbent who was defeated. And they all left office graciously, though certainly it was painful to be defeated. Never before had we had a defeated incumbent president, along with others, try to plot a coup that would keep him in office. Never before in the entire history of this country had there been a violent insurrection at the nation's capital. Thankfully, the guardrails of democracy held. Election officials in places like Georgia and Michigan refused to cave to the President of the United States. Judges, federal judges, state judges, Democrats and Republicans, all without exception, rejected claims that there were fraud, and each and every one of them said that the will of the voters and the will of the Electoral College had to be upheld. And on January 6th, Vice President Mike Pence said that he had to follow the Constitution and federal law and ultimately certify the winner of the election to Joe Biden. What if Mike Pence on that day had fallen prey to the pressures from the President of the United States and had declared that Donald Trump was the winner, notwithstanding the popular and electoral vote? That would have been the end of American democracy. So it's easy for us, after all this, to breathe a sigh of relief. As I said, the guardrails of democracy held. What I want to suggest to you this morning is that the events that brought us to January 6th, the underlying causes, are still with us today. And what I want to argue to you is we, all of us and all we know, need to take action, an immediate action and longer-term action to protect American democracy. Let me identify for you 3 things that I see as causing the threat to American democracy, then offer some directions for reform, and then hopefully conclude on a more optimistic note. One problem that contributes to what we saw happen January 6th stems to the Constitution itself. It's hard to admit it, but the Constitution is a deeply flawed document. And through a series of coincidences and good fortunes, often those flaws didn't manifest themselves. But now, even after all this time, they're coming to the fore. Obviously, some of the flaws of the Constitution were evident from the very beginning. The Constitution institutionalized slavery in several different provisions. It protected the rights of slave owners. From 1787, when the Constitution was written, until 1865, when the 13th Amendment was ratified, a period of 78 years, not once did the Supreme Court chip away at the institution of slavery or do anything but protect the rights of slave owners. And of course, we today are still dealing with that legacy of slavery. But let me point to some other flaws in the Constitution that are manifesting themselves right now. One is the Electoral College. Why did the Electoral College come to exist? In a democracy, shouldn't the candidate who gets the most votes be the one who's chosen as the chief executive of the nation? There's no other country in the world that has anything like the Electoral College. Well, in part, the Electoral College exists because of a distrust in the people. If you look at Alexander Hamilton's essays in the Federalist Papers, he said, we need the elite to choose the President of the United States, not the masses through popular election. Also, the Electoral College itself can be tied back to slavery. If the winner of the election, president, was based on the popular vote, then southern states that had slaves would have been at a tremendous disadvantage. Their slave population wouldn't have counted in the choice of president. Slaves obviously didn't get to vote. But the Electoral College helped them tremendously. Every state, as you know, gets votes in the Electoral College equal to the sum of its senators and its representatives. Every state gets 2 senators. I want to come back to that in a moment. Also, the Constitution said that in apportioning seats in the House of Representatives, slaves would count as 3/5 of a person. So southern states got a benefit for seats in the House of Representatives for their slave population that then translated into a benefit in the Electoral College. This is not just hindsight. At the Constitutional Convention in 1787, a delegate from North Carolina, Hugh Williamson, spoke of the benefit of the Electoral College in protecting southern states with slave populations. None other than James Madison, a representative of the Constitutional Convention of Virginia, said the same thing in praise of the Electoral College. Through a series again of coincidences and good fortunes, not once in the 20th century was a candidate chosen as president despite losing the popular vote. But twice in this century, in its brief history, we've had presidents chosen despite losing the popular vote. And it almost happened another time as well. In 2000 it happened, in 2016 it happened, and had Ohio gone for John Kerry rather than George W. Bush, Kerry would have become president, notwithstanding losing the popular vote. There is no way to reconcile the Electoral College with the most basic principles of democracy. But the problems in the Constitution go beyond that. Think of the United States Senate. Every state gets 2 senators regardless of its size. Now, in 1787, the difference between the smallest state and the largest state was 18-1. Now the difference between the smallest state and the largest state, Wyoming, is 88-1 in population. As a result of allocating 2 senators to each state, senators representing just 18% of the population could conceivably create a majority in the Senate. Right now, there are 50 Democratic senators and 50 Republican senators, but the 50 Democratic senators represent 60% of the population, and the 50 Republican senators represent only 40% of the population. But the problem is even worse than that. There's a Senate rule, it's not part of the Constitution, that creates the filibuster. The filibuster means that it takes 60 votes to pass anything in the Senate other than for confirming appointment for the Supreme Court or a federal judge or a cabinet appointment. So 40 senators representing a small percentage of the population can block what 59 senators representing a vast majority of the population want. There's no way to reconcile that with democracy. And of course, if we focus on the Supreme Court and the lower federal courts, they were always intended to be anti-majoritarian. But because of serious coincidences and because of manipulation of the process, we have a Supreme Court that's less representative and more ideologically imbalanced than perhaps any time in American history. Between 1960 and 2020, there were 32 years with a Republican president and 28 years with a Democratic president. In 2024, that will be even, 32 years and 32 years. But between 1960 and 2020, Republican presidents picked 15 justices for the Supreme Court, and Democratic presidents picked only 8 justices for the Supreme Court, almost a 2-to-1 difference. Or I can put this to you another way. Donald Trump picked 3 Supreme Court justices in his 4 years as president. The last 3 Democratic presidents, Jimmy Carter, Bill Clinton, Barack Obama, served a combined 20 years in the White House. And in those 2 decades, they together picked only 4 justices for the Supreme Court. And because of the nature of politics in the United States, there's a desire to appeal to a very conservative base, Republican presidents have picked very conservative justices. So the current court has 5 staunch conservatives, and Clarence Thomas, Samuel Alito, Neil Gorsuch, Brett Kavanaugh, and Amy Coney Barrett. And they're as conservative as any justices who have ever served on the Supreme Court in American history. And so I think we have to admit flaws in the Constitution and the way in which they contribute to the problems of democracy today. But second, I want to talk about the way that the Supreme Court that I've just described to you is contributing to the problems of democracy today. And I want to give you several examples of what the Supreme Court has done recently that I think pose grave threats now in 2022 and long-term to American democracy. Let me start with the issue of partisan gerrymandering. Partisan gerrymandering is the political party that controls the legislature, draws election districts to maximize, say, seats for that party. It's where, say, a Republican-controlled state legislature draws election districts to maximize their seats for Republicans, or a Democratic-controlled city council, where there's partisan elections, draws city council districts to maximize seats for Democrats. Partisan gerrymandering is nothing new. It's existed throughout American history. It takes its name from a governor of Massachusetts, Elbridge Gerry, who engaged in the practice. But what's changed is, because of sophisticated computer programs, it's possible to engage in partisan gerrymandering with more precision than ever before. Let me use an example here, a case that was decided by the Supreme Court just 3 years ago, in June 2019, Rucho versus Common Cause. It arose in North Carolina. North Carolina is basically a purple state. It went for Obama in 2008, Romney in 2012, Trump in 2016 and 2020, but also, as you know, always by close margins. And if you look at congressional votes in the state, they're almost exactly even in numbers between Democrats and Republicans. Republicans gained control of both houses of the North Carolina legislature, and then they decided to redraw congressional districts. And the leader of this process said they wanted to draw the congressional districts so Republicans would have control of 10 of 13 seats in the House of Representatives in North Carolina. And the person was honest. He said, we'll try to get more than 10 if we can figure a way to draw maps to do that. They had a computer draw 3,000 different possible electoral maps for seats in the House of Representatives in North Carolina. And they picked the one they thought gave Republicans the best chance of controlling 10 of 13 seats. In the November 2016 elections, Republicans and Democrats statewide got almost exactly the same number of votes for seats in the House of Representatives. But Republicans won 10 of 13 seats as planned. In 2018, the exact same thing happened. Well, Rucho versus Common Cause was a lawsuit to argue that this partisan gerrymandering is unconstitutional. It's tremendously undervaluing, giving too little weight to the Democratic voters for seats in Congress from North Carolina. A 3-judge federal court declared this unconstitutional as denial of equal protection, as a discrimination against people on account of their political party affiliation. But the Supreme Court ruled 5-4 that federal courts cannot hear challenges to partisan gerrymandering. Chief Justice Roberts wrote the opinion for the court. He was joined by Justices Thomas, Alito, Gorsuch, and Kavanaugh. Chief Justice Roberts said, if the courts would get involved in deciding whether partisan gerrymandering is unconstitutional, they'd have to figure out what's too much. And there's no way to draw that line. Justice Kagan wrote a blistering dissent. She said, whatever is too much, this is too much. This is the first time the Supreme Court's ever said it's not going to deal with a constitutional issue because it's too hard. There are all sorts of places where courts draw difficult lines. Justice Kagan said, in a democracy, it's supposed to be voters who choose their elected officials. Partisan gerrymandering means that it's the elected officials who are choosing their voters. Now, in California, we have an independent districting commission, so we don't have that kind of partisan gerrymandering. But there's only a handful of states with independent districting commissions. And what we're seeing in the districting after the 2020 census is partisan gerrymandering with a vengeance. And both Democratic-controlled legislatures and Republican-controlled legislatures are doing this. And it is a huge threat to representation in the democratic process. I mentioned earlier the difficulties with regard to choosing the president of the Electoral College, senators, the Supreme Court. The body that's supposed to be most representative of the people is the House of Representatives, but partisan gerrymandering is underlying that. The Supreme Court in the last decade has undermined one of the most important laws adopted in my lifetime, the Voting Rights Act of 1965. There is a long, tragic history of voting discrimination in the United States. And so Congress in 1965 passed a law to try to deal with this. And it's appropriate we talk about it today because it was this is the anniversary of the march from Selma to Montgomery that was so important in leading to the adoption of the Voting Rights Act. The Voting Rights Act did a couple of things that were particularly important. One is it said that jurisdictions with a history of race discrimination in voting would need to get pre-approval, pre-clearance it was called, before they had a significant change in their election practices. Do you know the arcade game Whack-A-Mole, where you knock it down in one place and it pops up in another? That's what Congress thought was going on with regard to southern states and elections. They'd adopt some restriction in voting, only for it to be struck down and another to pop up. So Congress says that jurisdictions that have a history of race discrimination in voting have to get pre-approval from the Attorney General or a three-judge court in Washington, D.C. This was tremendously effective. There were several hundred times when pre-approval was denied because election systems had a discriminatory effect against racial minorities. There are probably thousands of instances where southern states didn't even try because they knew pre-approval would not be granted. This law was supposed to expire in 2007. So in 2006, Congress held 16 different hearings. It produced a record of over 15,000 pages and voted to extend these provisions of the Voting Rights Act for another 25 years. The vote in the Senate was 98-0. Can you imagine the Senate today doing anything 98-0? In the House of Representatives, there are only 38 no votes. That noted liberal president, George W. Bush, signed it into law. The Supreme Court on June 25th, 2013, in Shelby County, Alabama, versus Holder, declared these provisions of the Voting Rights Act unconstitutional. It was the 5 conservative justices in the majority, Chief Justice Roberts writing for them, and Justice Ruth Bader Ginsburg, in one of the most famous dissents, writing for the dissenters, the 3 other liberal justices joining her. Now, what's interesting about this case is it's hard to figure out what constitutional provision, what constitutional principle does the Voting Rights Act violate? I teach constitutional law. I'm going to teach tomorrow morning at 8:30. I'm used to teaching cases about where the Supreme Court declares something unconstitutional. You say, well, it violates the First Amendment, or it violates equal protection. What did pre-clearance violate? Well, at the end of his opinion, Chief Justice Roberts says, this violates the principle of equal state sovereignty, that Congress must treat all states the same. But nowhere in the Constitution does it say anything about equal state sovereignty. I'm not one who believes in originalism, that the meaning of the Constitution is fixed when it's adopted. But if anything is clear about the original meaning, 14th Amendment, is that the Congress that ratified it didn't believe that Congress had to treat all states the same. That Congress also passed the Reconstruction Act that created military rule over the former rebel states. In his majority opinion in Shelby County, Chief Justice Roberts said, be reassured, there's another provision of the Voting Rights Act that will stop race discrimination in voting. This is Section 2 of the Voting Rights Act. It says that state and local governments cannot have election systems that discriminate against minority voters. Congress amended this in 1982 to say that proof of a racially discriminatory effect is sufficient to establish a violation of the law. On July 1st, 2021, in Brnovich versus Democratic National Committee, the Supreme Court gutted Section 2 of the Voting Rights Act. Brnovich involves a couple of Arizona laws. One said that a vote would be counted only if it was cast in a person's own precinct. The United States Court of Appeals for the Ninth Circuit, an opinion by Judge William Fletcher, found this had a discriminatory effect. Statistics showed that polling places were much more often moved in communities of color, and that many more votes of individuals of color would be disallowed because of this. The other provision of the Arizona law said that only a person or a relative could turn in an absentee ballot. Judge Fletcher in the Ninth Circuit found that in many Native American communities in Arizona, there's not reliable postal service, and this would have a discriminatory effect against Native American voters. The Supreme Court, in a 6-3 decision, reversed the Ninth Circuit. Justice Alito wrote the opinion for the court here, and was joined by the other conservative justices, Roberts, Thomas, Kavanaugh, Gorsuch, and Barrett. And Justice Kagan wrote a vehement dissent, probably regarded as one of her most important opinions coming on the court, joined by Justice Breyer and Sotomayor. Justice Alito said, there's many considerations that must be looked at in deciding whether there's a violation of the Voting Rights Act. And he said among these is we have to balance the state's interest in preventing fraud against the effect with regard to minority voter participation. Conservative justices are fond of telling us that we should interpret statutes just by looking at their text, their plain language. There is nothing in the Voting Rights Act, there's nothing in the history of the Voting Rights Act that suggests that we're supposed to balance the effects on minority voters against the state's interest in preventing fraud. Congress could have said that, but it didn't. And the Supreme Court upheld the Arizona restrictions. As Justice Kagan said, the Supreme Court said in Brnovich, is going to make it very difficult to challenge laws throughout the country that are being adopted that make it more difficult for people to vote. Since November of 2020, 18 states, all with Republican legislatures, have adopted laws that make it harder for individuals to vote. All of these are based on the premise that restricting voter turnout will help Republicans and hurt Democrats. I'm not sure that's true. But the one thing I'm sure of is this is going to have a discriminatory effect against minority voters in the United States. And as Justice Kagan said in her dissent in Brnovich, it's going to make it much harder to ever challenge these laws and have them struck down. So I think the Supreme Court, in making it impossible to challenge partisan gerrymandering, in gutting the Voting Rights Act, has created a serious threat to our democracy. Third, I want to talk about the threat to our democracy that comes from the loss of faith in government institutions and our deep partisan divide. We have never, as a country, been at a time where there's less confidence in the institutions of government. The last two presidents, Trump and now Biden, have had approval ratings just slightly above 40%. Congress' approval rating is 18, and I'm not sure if that's 18% or 18 people. A Gallup poll this past fall said that the Supreme Court's approval rating is the lowest that it's ever been in American history. The Supreme Court's approval rating, according to this poll, was 40%, and its disapproval rating was at 53%. And I fear that this is going to get worse. There's a case on the Supreme Court's docket right now. It was argued on December 1st, 2021, Dobbs versus Jackson Women's Health. It involves a Mississippi law that prohibits abortions after the 15th week of pregnancy. In Roe versus Wade in 1973, the Supreme Court said states can't prohibit abortion prior to viability, the time at which the fetus can survive outside the womb. In Planned Parenthood versus Casey in 1992, the Supreme Court said it was reaffirming, quote, the essential holding of Roe versus Wade, that states cannot prohibit abortions prior to viability. Medicine tells us viability is about the 23rd or 24th week of pregnancy. The Mississippi law, then, is clearly unconstitutional. But so is the Texas law that went into effect on September 1st that prohibits abortion from the 6th week of pregnancy. And the Supreme Court has allowed that law to remain in effect from September 1st, now more than 6 months. And I think it's a clear signal that the Supreme Court in Dobbs is likely to overrule Roe versus Wade. That I think there are 5 justices on the current court. An oral argument certainly shows this. Justice Thomas, Alito, Gorsuch, Kavanaugh, and Barrett, who will overrule Roe and leave abortion entirely to the political process of the states. In some states, like California, abortion will remain legal. but in about half the country, there are laws prohibiting all or almost all abortions. Women in those states with resources will travel to places like California and New York when they want abortions. Before New York became the first state in this country to legalize abortion in the 1960s, 25% of all the abortions in England were performed on American women. It wasn't poor women who were going to England for abortions. It's going to again be poor women and teenagers who will face the cruel choice of the unwanted child and the unsafe back alley abortion. But I think it is going to have a real effect on the Supreme Court's legitimacy. The most recent polls I show that 2/3 of Americans believe that Roe versus Wade should be upheld and continue. What will it mean for the Supreme Court's legitimacy to overrule such a landmark decision that women have relied on now for half a century? At the oral argument in Dobbs, Justice Sonia Sotomayor said, and I'm quoting, "How can the court overcome," and this is her word, "the stench that will attach to it if it overrules this long-standing precedent?" And what will it mean for our country and our democracy if the Supreme Court's approval ratings plummet further? And of course, underlying the low approval ratings is the deep partisan divide that exists in our country. We are more politically divided as a nation than we've been at any time since the Civil War. Every study, every poll supports this. 70% of registered Republicans believe that Donald Trump won the 2016 presidential election, even though every judge, as I said, state and federal, found no evidence of this and no evidence of fraud. 16% of the American people believe that QAnon is right, that the federal government is being run by a pedophile ring, and there'll be a violent change in the government to come. 16% of the country believe what QAnon says. Recently saw a poll that says both 35% of Democrats and 35% of Republicans would be very upset if their child married somebody of a different political party. Far more than the number of people that object if their child married somebody of a different race or a different religion. So if you put all of what I've said together this morning, you can see why I say that American democracy is in grave danger. So what do we need to do about it? I think we need to do things quickly. First, we need to recognize the problem. And I think that it's too easy for people to be sanguine after January 6th and convince themselves that the guardrails of democracy will be there. We need to look for the things that unite us as a country and try to emphasize those and not those that divide us. The things that most have the opportunity for uniting a country are crises. The last time this country was really united was after September 11th. The president's approval ratings were over 90%. Unfortunately, the misguided war in Iraq squandered that, and we've never had that unity since. There was the opportunity for the pandemic to unify the country. After all, if Donald Trump had said March of 2020 that this is a health emergency and we need to come together, we need to listen to science and medicine, we had the chance for the country to be united. But unfortunately, the pandemic's only further divided the country. Perhaps the tragic Russian attack on Ukraine will be an opportunity to unify the country. But even here, we see some from the far right astoundingly praising Putin rather than condemning him. But I think it's all of our responsibilities to find ways to bring our communities and our country together for what unites us. Second, in the longer term, we must do a better job of civic education than this country has done in recent years. More people can name some of the seven dwarfs than can name Supreme Court justices. When you think it's the Supreme Court justices that make such crucial decisions about our lives, most intimate, important aspects of our lives, that's tragic. You see a candidate for the Senate in Alabama who didn't even understand there were two houses of Congress. And that's not a caricature. Well, we have to go in to the elementary schools, the middle schools, and the high schools. We need to go to Rotary clubs and Lions clubs and any other organization you're part of and engage in civic education. It's nonpartisan, but we all have to understand government better if we're going to save democracy. Third, we need to adopt legislation to protect the right to vote. Making sure that every person can vote is nonpartisan. And so we need to find a way to get Congress to adopt the legislation that would repair the Voting Rights Act. It almost happened. Proposed legislation to repair the Voting Rights Act passed the House of Representatives. It would have passed the Senate, but for two Democratic senators who would not vote to lift the filibuster to get it through. We need to pressure those senators. We need to pressure Congress to repair the Voting Rights Act to protect the right to vote. At the very least, we need to have Congress pass a law that before the next presidential election will cure the ambiguities that almost led to disaster on January 6th. There's a law called the Electoral County Act of 1887, and it governs how votes are to be counted in Congress and how the Electoral College process is to work. It has many gaps and ambiguities. Thankfully, there's a bipartisan effort in Congress. Republicans like Susan Collins, Democrats like Dick Durbin are leading it to repair this statute, among other things, to make absolutely clear the vice president can't decide who's going to be the next president of the United States. But we need to pressure members of Congress to adopt law like this, or it's not going to happen. There are other things that need to be done to change the process. We need to combat partisan gerrymandering. We have an independent districting commission in California, but we need to pressure other states to adopt independent districting commissions like ours. It shouldn't be that elected officials get to choose their voters. Finally, in the longer term too, we need to think about constitutional reform. We've got to find a way to get rid of the Electoral College so that people can choose the president. We need to rethink the Senate in terms of every state getting 2 senators regardless of size. We need to rethink the United States Supreme Court, considering things like term limits, considering things like even changing the size of the Supreme Court. Maybe, and perhaps still unthinkable, it's time to consider a new Constitution of the United States, replacing one that was written so very long ago. This is a hard time to be teaching law students and undergraduates constitutional law. I've never seen my students more dispirited about the future of the Constitution and the future of democracy. And yet what did I tell them, and I say this explicitly, is we really only have 2 choices. Either we give up or we fight harder. And to me that means, as I say to them, there's only one choice. We have to fight harder and better than we have before. And I said, my cause for optimism comes from looking at the history of this country and from world history. If you look at it, there's been such tremendous advances with regard to equality and freedom. There's tremendous racial inequality in this country too. But think of what it was in 1787 or 1868, or even the year I was born, 1953, when every southern state had Jim Crow laws that mandated apartheid. Or think about gender equality. The law school I went to had 5% women students in 1970. It was 25% women students when I started in 1995. Today, the law school where I'm dean is 2/3 women students. We can look at every society, and though there's an enormous way to go in terms of gender equality, think of the progress that's been made. Or think of the progress that's been made with regard to gay and lesbian rights. It's not quite 7 years ago, on June 26, 2015, that the Supreme Court in Obergefell versus Hodges said that laws that prohibit marriage equality for gays and lesbians are unconstitutional. Or think about freedom. Think about our freedoms with regard to speech and religion and how much they've advanced over the last 200 years. And so the message that I try to transmit to my students, my message of optimism, is best captured in the words of the late Dr. Martin Luther King Jr. when he said, "The arc of the moral universe is long, and it bends towards justice." Thank you so much. Thank you.
One more moment of optimism, Dean, is the signs that used to exist in many places in the country that said no Jews allowed to live in certain areas, and the quotas for Jews to be able to go to law school and medical school and whatnot. So we so appreciate your optimism, given the first 45 minutes of that lecture. Whereas I looked around at the faces of the individuals sitting in this congregation, I can only imagine those who were watching saying, "What in the heck did you do to bring this person?" But so important to hear the challenges that we have. So important to hear the opportunities that we as a community committed to justice have. So important for each and every one of us to understand what Dean Chemerinsky said, that the future of this country lies in each one of our hands. And what a gift and a challenge and an enormous burden that is for every single one of us to understand the role that we must continue to play. So I am certain that many of you have questions. Questions of challenge, questions of agreement, questions of opportunity for Dean Chemerinsky, and I would like to give you an opportunity to ask those questions, obviously with respect. Some of the questions that I had you answered at the very end, but I want to start just by asking to push a little bit on the question that I was going to ask you, and then we'll open it up to all of you. There is much conversation about term limits for Supreme Court justices. You know, we've heard the Jewish number 18 years, chai, how appropriate, if there are going to be term limits. And I'd like to ask you, how would something like that transpire? How would challenges to or amendments to the Constitution begin, especially if there are individuals sitting here and elsewhere that would like to see those kinds of changes made?
Sure. Let me just back up a second and explain why I believe term limits for Supreme Court justice is a good thing, and then I think I can answer your question of how do we get there. Thankfully, life expectancy is a lot longer today than it was in 1787. In 1787, when the Constitution was written, average life expectancy was 36 years. Think about this in terms of the justices on the court. Clarence Thomas was 43 when he was confirmed in 1991. If he stays on the court until he's 90, the age which John Paul Stevens retired, he'll be a justice for 47 years. So this doesn't sound partisan. Elena Kagan was 50 when she was confirmed. If she stays on the court till she's 90, that's 40 years. Or I'll put it another way. The most recently confirmed justice to this point was Amy Coney Barrett. And when she was confirmed on October 26, 2020, she was 48 years old. If she stays on the court until she's 87, the age which Justice Ginsburg died, she will be a justice until the year 2059. This is just too much power in a single person's hands for too long a period of time. And too much depends on the accident history when vacancies occur. Richard Nixon got to pick 4 justices in his first 2 years as president. Jimmy Carter got no picks for the Supreme Court in his 4 years as president. 18-year non-renewable terms. Why 18? Rabbi, I like your explanation best. But it's actually because 18 is divisible by 9 into 2. And so then you'd have a vacancy every 2 years, and every president would get an equal ability to influence the outcome of the composition of the Supreme Court. I think it would take a constitutional amendment to do this. There are those who believe you could do it by statute, but Article 3, Section 1 of the Constitution does say the Supreme Court and the just and inferior courts shall have their positions for life, assuming good behavior. So I think it would take a constitutional amendment. And the good news is there's bipartisan support for it. For example, conservative Republican Texas Governor Rick Perry, in running for president, urged 18-year non-renewable terms. And liberals argue for 18-year non-renewable terms. The question is there a constituency that cares enough about this to do the hard work to get the constitutional amendment passed? And here I think the answer to your question, Rabbi, is for people through the organizations they're part of, especially civic-oriented organizations, to press for their representatives and senators to vote in favor of an amendment. And I don't hear partisan opposition, especially because it wouldn't affect the existing sitting justices. It would be triggered after these justices finish. It's not removing anyone from the current court. So I think it's possible, but I think it would be very difficult.
My last question was, how can we sign up for your daily and weekly lectures?
Oh, you're very sweet.
Maybe we can all reapply to go to school again, just for the opportunity to listen. So let me open it up. Carrie has a microphone. If you would like to speak, please raise your hand, and Carrie will bring the microphone over. And actually, since he's right there, Rob. Carrie, thank you.
Since I have the mic, can I ask a question? You didn't talk about money in politics, and it's something that sort of disappeared since the Supreme Court decided that money was fine in politics. So, talk a little bit about that and what you think that means for the country.
It's so interesting. That's one of the first questions. I wrote this lecture yesterday, and in the second part of the lecture, when I had the Supreme Court, I had money in politics and the Supreme Court's decision in Citizens United is part of it. And I wanted to make sure I stayed close to my 40 minutes, and then I took it out for time reasons, and now I wish so much I had left it in. It's so perfect. In 2010, in Citizens United versus Federal Election Commission, the Supreme Court ruled 5-4 that corporations have the right to spend unlimited amounts of money in election campaigns to get candidates elected or get candidates defeated. And that has had a tremendous corrosive effect on public confidence in elections. And also political science have documented, especially at lower visibility elections, not the presidency, maybe not even senators, but in state and local elections, who spends the most is often key in terms of who wins. I don't believe corporations have free speech rights. And even if they did, I think there is a compelling government interest in leveling the playing field and restoring confidence in the political process. Unfortunately, given the current composition of the Supreme Court, this isn't going to be reconsidered. But there are things that can be done that haven't been done. We can have much stricter disclosure laws with regard to campaign spending. There's too much dark money where we don't know the source. And it might be benefiting Democrats, it might be benefiting Republicans, but at the very least we should know who's giving the money. Also, I think we could adopt a law at the local level, the state level, the federal level, that corporations that contract with that level of government cannot spend money in the election campaigns for candidates for that level of government. We already have laws that say that civil service workers can't participate in political campaigns. It's called the Hatch Act at the federal level. I think we could do the same thing to say that if a business is contracting with the city of Los Angeles, then it shouldn't be spending money as to who gets elected for the city council or for mayor. And I think that would be constitutional and a step forward. So again, Rabbi, in terms of the latter part of my remarks, there are things that we can do, disclosure laws, restrictions like I mentioned, but we have to do them. And I think this is key to restoring confidence in the electoral process. So I'm so glad you asked that question.
All right, so I see Rob, and then is it Charles? Next. So Rob, go ahead first. Bruce.
So, Professor, given what you said about the overwhelming majority in favor of Roe versus Wade, why don't you think there's been more of a push for a constitutional amendment for abortion to take it out of the hands of the Supreme Court?
To adopt a constitutional amendment would take 2/3 of both houses of Congress and then ratification by 3/4 of the states. Over half the states will have laws that prohibit some or almost all abortions. Abortion has become a very important issue in rallying the Republican base. And so in the states with Republican legislatures, they're not going to pass a constitutional amendment to protect the right to abortion. They're adopting laws to prohibit abortion. And now where I'm going back on the bleak path, I will give you a prediction. When Roe is overruled, the next time there's a Republican president, a Republican Congress, they will try to adopt a national law prohibiting all abortions, preempting the ability of states like California to allow abortions. So I don't see a chance for a constitutional amendment to either allow or prohibit abortion, but I do see a prospect for national legislation, and I'm very worried about that.
Bruce, and then Peter, and then Steve, and then Peter.
I'd be very interested to hear your thoughts about the conundrum of trying to maintain the integrity of the First Amendment and yet doing something to censor the massive disinformation and misinformation that pollutes the national discourse.
I think you've raised something that also is an important threat to democracy. Democracy depends on freedom of speech. It's the way in which we learn about our government, it's the way we criticize government, it's the way in which we decide who to elect. But because of the internet and social media, there's an enormous amount of misinformation that's available, disinformation that's there. I mean, in many ways, the internet and social media have created a golden age of free speech. I mean, it used to be that in order to reach a mass audience, you had to be rich enough to own a newspaper or get a broadcast license. Now, any of us with a smartphone, and access to a modem, can reach a mass audience. We have immediate access to infinite amounts of information. And yet, this golden age also has a real dark side in exactly the way you say, the misinformation and disinformation. And how do we deal with it? And here I don't have an answer. I've not seen a good solution to this. A group of deans and professors at Berkeley, the dean of the journalism school, Gita Anand, Janet Napolitano, who's a former governor of Arizona and head of the Department of Homeland Security, is now a professor at the School of Public Policy. The dean of the School of Information Science, Jennifer Chase, and I have started a working group to try to focus on this issue, to think if we bring, at least the Berkeley campus, some of the individuals across campus working on the issue, maybe we can come up with some ideas. And we've created a seminar of students to work on this, but I don't have any solutions at this point. How can we deal with the misinformation without running afoul of the First Amendment? Certainly we don't want to give the president and the government the power to censor that which they believe to be false. We wouldn't want the president to be able to do that. But how do we deal then with the false information? And I think you put your finger on an enormously important problem, but one for which I don't have any answer to suggest.
Steve Rasnick.
Professor, thank you very much for coming.
Steve, take off your mat just so it's easier to hear you. I know that makes you uncomfortable.
Right place to thank God, right? Professor, thank you very much for coming. It was enjoyable speaking to you before breakfast about my Uncle Jerry Hall at Hastings and all of that. I understood very clearly your position on the Republicans disenfranchising certain people. What I didn't hear about, perhaps you can help explain to me, is why the Democrats have pushed for these specific platforms. Packing the Supreme Court, statehood for Puerto Rico and D.C., a 16-year-old vote, felons both in and out of prison having the right to vote.
Can I do these one at a time?
Sure.
Once you get past two, I'll go through them one at a time for
To
you.
me, you're welcome to, but to me,
Please
they
do
don't
them
have
one
the
at a
same
time,
answer.
because it's going to be much harder for me to go through the list by memory.
Why do the Democrats push for packing the Supreme Court?
I believe there is a substantial ideological imbalance in the Supreme Court by virtue of the statistics that I gave you. And I think there's an argument that says we should have a much more ideologically balanced court. Next example.
The Democrats, as we know, have pushed for and succeeded in an open border between the United States and Central and South
I
America.
don't accept that characterization at
Please,
all.
I won't interrupt you. Please let me get my question out. They've pushed for open borders and have succeeded in astronomical numbers. They've allowed all of the Hispanic countries to be able to enter the U.S., including Caribbean countries such as Haiti. But Biden directed Mayorkas to prohibit Cubans from coming here, a traditional Republican voting bloc.
I don't accept the characterization that the Democrats have engaged in open borders. I don't think that that reflects the current reality. I am not an immigration expert, so I'll skip that and just focus on your constitutional law examples.
Why this, I'm going to put two together now, if you'll allow me. Why have they pushed for a 16-year-old vote and voting rights for felons both in and out of prison?
Okay. I had not heard about the push for 16-year-old votes, so I can't speak to that. In terms of felons, as I understand, I favor allowing people after they've served their sentence to vote. I don't favor people while they're serving their sentence to vote. And the reason for that, I don't believe people, when they've served their time, when they've done their assigned prison service, should lose privileges in society, including the privilege to vote. I don't believe in permanent disenfranchisement of anybody. The usual philosophy of our country with regard to punishment is we take away those rights that are necessary to facilitate incarceration. There's no reason to have permanent ex-felon disenfranchisement. And statistics show it does have a tremendous racially discriminatory impact.
And lastly, that please many people here, illegals are allowed to vote in certain Democrat-controlled jurisdictions. Are you in favor of illegals coming here, having no citizenship, perhaps not the ability to even read the ballot, never paying taxes, but be allowed to vote in certain local Democrat-controlled jurisdictions?
No, I don't favor that, but nor had I heard of any jurisdiction that allows undocumented individuals to vote.
Thank you. Thanks, Steve. Peter, yes.
Yeah,
Peter.
that's interesting because that was my question. And it arose because I believe you used the phrase people when you said you believe all people should have the right to vote. And I was about to ask, although I guess it's now been asked and answered, your feeling about folks who are not citizens eventually voting, getting to the voting booth because there's not much to stop them. Where do you stand on that?
First, to my knowledge, no jurisdiction allows those who are undocumented to vote. Almost no jurisdiction allows non-citizens to vote. And the evidence shows very little fraud overall or in this regard. I actually find the question of those who are lawfully in the country but not citizens in voting a difficult question. I don't find it a difficult question for those who are illegally in the country. And the reason is that those who are lawfully here pay taxes just as you and I do. They're governed just as you and I are governed. And so there's a part of me that says that, those who engaged in the Boston Tea Party were right. No taxation without representation. On the other hand, there's a part of me that also believes that a core aspect of citizenship is the ability to vote. And so it makes sense to exclude non-citizens the ability to vote. So I don't know where I stand on non-citizens who are lawfully here, but I oppose the right to vote for non-citizens who are not lawfully here, but I've never heard of a jurisdiction that allows that.
Ellen, yes, and then after Ellen, Dan.
Good morning. I enjoy your work in the LA Times, Professor.
Thank you.
My question is, you make a point about that we have an opportunity to influence people in legislators in other areas of the country. And I know sometimes my friends back east tell me that I don't really have to work so hard because I live in California. So I wonder, what is a way that people in California can influence legislators in other parts of the country? That's just a question.
Sure. There are many ways. One is by being part of national organizations. As individuals, we're limited in our influence. But if we gather together with others who have similar views, we have the opportunity to amplify our voices. And so, whatever issues you care most about, what are the national organizations? And those national organizations have the opportunity then to be involved in the state and local elections across the country. But let me also take it in a very different direction. When elections are held next November, or November 2024, there's the opportunity to go be poll watchers in those places. And poll watchers are going to be very important. And if you have the ability and the time to travel, that's a place to go and have a positive effect to ensure the integrity of the elections in those places.
Dan and then Zena. And then I think we're going to just take one more just because I'm looking at the time. So one or two more. Yeah, Dan, go ahead.
Hi. Getting back to what you were saying about the guardrails of democracy having almost been broken, I would like to ask you to comment on the evolving Second Amendment jurisprudence.
Sure.
Because it seems like we're moving in the direction of allowing people to carry weapons in crowds, which seems to be something that could threaten our democracy.
Sure. From 1791 until June of 2008, not one federal, state, or local law was struck down for violating the Second Amendment. In the handful of Supreme Court cases about the Second Amendment, the Supreme Court said it means what it says. The exact words of the Second Amendment are, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. And the Supreme Court said the Second Amendment is about right to have guns for the sake of militia service. In June 2008, in District of Columbia versus Heller, the Supreme Court said that the Second Amendment protects the right of people to have guns in their homes for the sake of security. It involved a 35-year-old DC ordinance that prohibited ownership and possession of handguns. And the court was split 5-4, the 5 conservative justices in the majority, Justice Scalia writing for them, the 4 liberal justices dissenting, Justice Stevens and Breyer writing for them. That was the last Supreme Court case about the scope of the Second Amendment. But there's a case pending right now. It's New York Rifle and Pistol Association versus Bruin, and it was argued on November 3rd of 2021. It's awaiting decision. And it involves a New York law that prohibits having concealed weapons in public. And it says, in order to have a concealed weapon, it's necessary to have a concealed weapons permit. A permit will be granted only if a person can show a safety need for having a concealed weapon. The New York law is over 100 years old. I think it's clear that the Supreme Court is going to strike down this law. I think the court's going to say there is a right to have guns in public. It's not clear to me whether the court's going to say there's an absolute right to have concealed weapons or allow some government regulation of concealed weapons, but that then directly answers your question. And this, like abortion, is an issue that deeply divides conservatives and liberals, with conservatives reading the Second Amendment as a right to have guns, and liberals reading the Second Amendment is just about a right to have guns for purpose of militia service. And conservatives favoring gun rights and liberals favoring gun control. And we have a conservative majority on the court. So I think they're going to go very far in that direction, and we'll get some indication this spring when this case is decided.
Zena.
Good morning.
Good morning.
Thank you first for being here and sharing your time with us, and also for allowing me to understand you through your insights a little bit more. Beyond Bakke, in the evolution today, whether it's discourse, what schools and legislatures are attempting to do, can you comment and provide your insights on where the education admission process is going, be it deconstruction of the LSAT to getting rid of it, whether these are institutions that are publicly owned through the taxpayers or privately owned and boarded? I'd like to hear where you believe education admission process is going, and where you think the courts will go
Sure.
in perhaps responding to some of those types of issues. Thank you.
Sure. You mentioned at the beginning of your question, Bakke. The case was Regents of the University of California versus Bakke in 1978, and the Supreme Court held that college and universities have a compelling interest in a diverse student body. College universities may use race as one factor in admissions decisions to benefit minorities and enhance diversity. In 2003, in Grutter versus Bollinger, the Supreme Court 5-4 reaffirmed that. And in June 2016, in Fisher versus University of Texas Austin, the Supreme Court reaffirmed that. But two of the justices in the majority in Fisher were Justices Kennedy and Ginsburg, and they're no longer on the court, and they're replaced by two much more conservative justices in Kavanaugh and Barrett. The reason I set up the answer this way is the Supreme Court has granted review in two cases for next term. Students for fair admission against Harvard University and students for fair admission against the University of North Carolina. And they both asked the question of whether college universities can continue to use race as a factor in admissions decisions to benefit minorities and enhance diversity. Why two cases? Well, the Constitution applies only to the government, and so University of North Carolina has to comply with equal protection. Harvard's private, it doesn't have to comply with the Constitution. But Title VI of the 1964 Civil Rights Act says recipients of federal funds can't discriminate based on race. The Supreme Court has said the standards under Title VI are the same as under equal protection, and so that's the Harvard case. I have no doubt that the Supreme Court is going to overrule Bakke and Grutter and Fisher. And if you think that affirmative action is undesirable, you'll applaud this. If you think that affirmative action is necessary for diversity, you'll criticize this. Though interestingly, it will have less effect in California than the rest of the country. Because in 1996, California voters passed Proposition 209 that already eliminates affirmative action in the state, including in admissions. So I think there's going to be a dramatic change in the law and a big effect, though we'll see it less in California.
Melody and then Mark.
Thank you. I'm wondering if you can tell me whether there's been any literature, I haven't found any books on it, which have approached the issue of abortion from the standpoint of limiting it is a violation of religious freedom.
I can show you someone who made that argument, and I can, if you'll send me, I can see you a citation. Lawrence Tribe made that very argument at the time of Roe versus Wade, but he later repudiated it. And the reason is many laws can be tied back to religious teachings. The fact that a law might be traced back to a religious belief doesn't make the law unconstitutional. And so Tribe originally made that argument, and then he said, no, I'm wrong, because the fact that religion might support a law isn't a reason why the law is unconstitutional. I mean, it very well might be that we could take many laws that exist and trace them back to religious teaching, but that doesn't make the laws unconstitutional. That's what the argument is, and that's why the argument hasn't gotten traction. But I can give you a citation if you want, and answer to your specific question.
Mark. And then Cindy.
Thank
and
you
I think
for-
we're going to close.
Thank you, Professor, for your presentation. It's very educational. And I believe it's definitely a perspective from one side of the political spectrum.
Sure.
And I'm sure that hopefully someday we'll have someone from the other side be as persuasive and articulate, present the other side, which speaks to the polarity that you speak of, that we all, I think, are aware of. But I think also we're probably aware that a large majority of moderate Democrats and moderate Republicans probably agree on 90% of the issues, or at least come to some agreement of what the possible solution would be, but it doesn't seem like our legislatures are able to work together to achieve that. What do you feel is the primary constraint that's preventing our representatives from coming to some sort of compromise to help deal with these issues that many of us probably agree on, with whatever side of the spectrum we lean towards?
I want to say two things. One is I don't hide my political views, and obviously they influence what I say. And yet, I would hope, as to most of what I talked about, it's not partisan. I would hope Republicans and Democrats could both agree that Electoral College makes no sense in a democracy. I would hope Republicans and Democrats would both agree that the current composition of the Senate, 2 senators per state, with Wyoming getting 88 times more influence than California does, just doesn't make sense. I would hope that Republicans and Democrats might both agree that come the year, say 2030, when we don't know who's in power, we're going to get rid of the filibuster. Because allowing senators representing, 40 senators representing a small part of the state is inconsistent with democracy. I don't see that as liberal or conservative. I don't think objecting to partisan gerrymandering is liberal or conservative. I don't think the premise that everyone should be able to vote and vote freely is liberal or Democrat. And so I hope you will have many lecturers come in memory of Lisa, and I hope you have liberals and conservatives come speak. But I guess I don't believe most of what I said today was liberal. I think the question you ask is an enormously important one for us all to think about. Because whether we are liberal or conservative, we all want so many of the same things for our community and our country. Why can't we find ways to unite behind them? Why can't we have more candidates at every level who appeal to our shared common interests rather than appeal to what divides us? I think it's the things that we've talked about here. I mean, some of it was the question about money in politics helps influence that. I think the Electoral College helps influence that, because I think that candidates know that they can get elected without needing to appeal to a broad-based consensus. I think that partisan gerrymandering contributes to that. It's astounding to look at the maps that are being drawn in some states now. And I condemn partisan gerrymandering was done by Democrats or Republicans. But you know, somebody asked a great question about social media. Ultimately, we're responsible for the discourse that exists in our society too, and what we consume and how we talk to each other. So I don't have great solutions to your question, but I do think we have some personal responsibility.
Thank you, Mark. Final question, Cindy. I hope that everybody online has been able to hear the microphone questions from the audience. Some have been louder than others, so we apologize if you have not been able to.
Professor, my name is Cindy Sands. I just returned from Utah, going over there during the COVID, and I'm back in California now, and I was living there amongst people that truly believe that Trump is still the president. I just want to humbly thank Lisa and her family, and you, Professor, for being here today and presenting what you did. I'm overwhelmed. I'm overwhelmed and inspired by you, and I want to volunteer and be involved at a level in which I can make an impact with others of like mind. I want to thank you for that, and I humbly thank all of you, wonderful, beautiful people. Thank you.
Cindy, thank you. What a wonderful way to conclude this afternoon by reminding each one of us that we can certainly get involved in causes that we care so much about. And Mark, as you said, the need to come together for the things that we agree about is so much more important than staying divided on the things that don't unite us. And so thank you for your comment, for all your comments. I want to invite Peter to come up to present to you, Dean Chemerinsky, a little token of appreciation for your being with us to honor and remember Lisa.
Well, first of all, just non-politically, must say that it's just a great honor. Our family, Marion, myself, and our whole family thinks this was a fantastic way to kick off the series in Lisa's memory. And it was a mitzvah for you to be here.
Thank
Appreciate
you.
it.
Thank you. My enormous honor. Truly my honor.
And the synagogue would like you to have a gift to remember your visit with us.
Thank you.
Thoughtful and thought-provoking for sure.
Thank you so much. Thank you. Thank you.
Marion and Peter, thank you to all of you. May we leave these halls with a renewed sense of purpose and meaning in our lives. Tzedek Terdof, our tradition teaches us, it's not enough just to want justice, we must pursue it at all costs. May we do just that and live the memory of Lisa. And thank you once again, Dean, for being with us. We hope you all have a safe and good afternoon.